Welcome to While We Were Distracted, the podcast where we explore topics that often get overshadowed in the rush of daily life. Please take a moment to like and subscribe, it really helps.
Today, we're really digging into something significant. It's this recent court-supervised agreement, the one between the Trump administration and the American Federation of Teachers, the AFT. And it's all about student loan forgiveness.
That's right. A really big deal.
So what we want to do here is, cut through some of the noise and the policy speak. We want to lay out what this deal actually means, not just like in theory, but for the millions of people affected.
Absolutely. People waiting for relief they were legally owed.
Exactly. And we also want to unpack the mechanics behind it, the debt relief itself, why it even took a lawsuit from a major union to get things moving.
Which says a lot in itself.
It really does. And then there's this critical piece about avoiding a potential financial nightmare, the tax bomb. We'll definitely get into that.
Yeah, that part's crucial. This agreement, it basically resolves months of pretty serious legal tension. We're talking about the government's actual obligation, under existing law, mind you, to cancel debt for borrowers.
So this isn't new policy, this is enforcing old policy.
Precisely. It's about making sure people who've made payments for decades under plans Congress set up actually get the forgiveness they were promised.
Yeah.
It's a huge win for borrowers who were just stuck, completely stuck in limbo.
Okay, so let's start there with that friction. If the law already said this debt should be canceled, what specifically pushed the AFT to file that lawsuit back in March 2025? What was the flashpoint?
Well, it wasn't subtle. It was actually quite direct and, frankly, disruptive. Sources confirm the administration did two key things.
Okay.
First, they just pulled the income-driven repayment, the IDR, enrollment applications right off the federal student aid websites.
It's gone.
Just
vanished.
And second, they quietly told the loan servicers to just stop processing any new IDR applications. Full stop.
Wow.
So it wasn't just a slowdown. They effectively, flipped the off switch for these programs. And this came after they had already paused forgiveness processing under some IDR plans earlier in the year.
So, okay, they put up these massive roadblocks. Did they give a reason? What was the official justification for basically halting legally mandated relief?
They did have an official line. The Education Department under Linda McMahon argued that, well, their hands were tied. They pointed to a separate court order.
Oh, right.
Yeah, one that had paused the Biden administration's SAVE plan, Saving on a Valuable Education.
Okay.
So the administration's statement basically said they needed to stop things to, and I'm quoting loosely here, separate out the illegal loan cancellation schemes. Their words. The idea, supposedly, was to clear the decks so they could then process what they called legitimate loan cancellations once again, trying to link the halt to the SEV plan issue.
But the effect wasn't just on SEE, right? It sounds like it stopped everything.
Exactly. That was a practical outcome. It caused a system-wide halt, whether the cancellation was tied to SAVE or these other long-standing congressionally approved IDR plans. Everything just stopped.
And the impact on borrowers must have been immediate and huge.
Oh, absolutely huge. Suddenly, these temporary blocks meant people effectively had only one repayment plan left that could eventually lead to cancellation, the old income-based repayment plan.
Just one option.
Pretty much. And consumer advocates were sounding the alarm immediately. They warned that cutting off these other options, especially with SAVE pause, could mean monthly payments jumping by hundreds of dollars for ordinary people.
So it felt less like a procedural cleanup and more like relief being actively blocked?
That's certainly how it was perceived, and you can see why. It felt like the system was being shut down through these administrative actions.
Which brings us back to the AFT lawsuit and this agreement.
Exactly. That blockage is precisely what the AFT challenged in court. And the core of this agreement, the settlement, is actually quite straightforward. It mandates the administration must, quote, follow through on the forgiveness for everyone eligible. No more delays.
It forces them to turn the power back on, basically.
That's a good way to put it.
Yeah.
It compels the Education Department to restart the machinery for these specific, legally required programs.
Okay, let's get specific then. Which programs are we talking about? The ones where relief was already mandated by law.
Right. The agreement covers four key established programs. These are the General Income-Driven Repayment Plans, or IDR.
Okay.
The Income Contingent Repayment Plan, ICR. The Pay As You Earn Plan.
Pay As You Earn, got it.
And of course, the Public Service Loan Forgiveness Program, PSLF. All congressionally mandated roads to forgiveness.
And aren't a couple of those, ICR and Pay As You Earn, already on their way out under separate plans?
That's a really important point, yes. Both ICR and Pay As You Earn are scheduled to be phased out by July 1st, 2028. That's part of President Trump's proposed big, beautiful bill aiming to simplify repayment.
So there's an added urgency to process those.
Definitely. While the phase-out is planned for the future, you've got, I think, over 2.5 million people currently enrolled in just those two plans. They need their forgiveness processed now, under the rules they enrolled under, before the programs potentially disappear.
And this agreement sets a hard deadline for that processing, right?
It does. Critically, it requires the debt cancellation to happen in 2025, this year. That timeline is paramount.
Okay, and what about people who might have overpaid? Like they qualified for forgiveness months ago, but kept paying because the system was backed up.
The agreement addresses that too.
Hmm.
It explicitly requires reimbursement for borrowers who made payments after they officially became eligible for cancellation.
That seems only fair.
It is. It corrects a long-standing, frankly frustrating issue with the system. For years, people were sending in checks when their balance should have already been zero. Think about that.
Yeah, paying on a debt that doesn't legally exist anymore.
Exactly. It's like, yeah, paying rent after you moved out. The system failed them, and this agreement forces that correction and the payback.
The agreement also mentions processing something called buyback applications. What's that about?
Right, the buyback.
Yeah.
So the department also has to process IDR and PSLF buyback applications. This is pretty important for some folks.
How does it work?
It essentially lets borrowers make sort of lump sum payments to get credit for past periods where their payments might not have qualified for technical reasons, or maybe periods they were in the wrong kind of deferment or forbearance.
Oh, okay, so it helps them catch up to the forgiveness threshold faster.
Precisely. It helps people bridge gaps in their payment history. Maybe administrative errors, confusing advice in the past to reach that 20 or 25-year mark needed for cancellation under IDR, or the 10 years for PSLF. It streamlines things.
Okay, this is all really helpful context, but let's zoom in on that deadline, December 31st, 2025, because that connects directly to this tax bomb issue. Can you break that down for us? What exactly is this threat?
Yeah, the tax bomb. It sounds dramatic, but the threat is very real. It all comes down to how the IRS usually treats forgiven debt.
Normally, it's income, right?
Normally, yes. If a debt you owe, like your credit card debt, gets canceled, the IRS typically says, okay, that canceled amount counts as taxable income for you that year, like you earned it. Big ouch, especially with large student loan balances. Now, there have been temporary exceptions for student loans. For instance, the American Rescue Plan during the Biden era temporarily shielded forgiven federal student debt from federal income tax.
But that protection is expiring.
That's the crux of it. That specific protection is set to expire at the end of 2025. Starting January 1st, 2026, the old rule potentially snaps back into place.
Meaning any student debt forgiven after that date could suddenly become taxable income.
Potentially, yes. That's the looming threat the AFT referred to, this change in federal tax law kicking back in for 2026. Imagine getting, say, $50,000 in student loans canceled, only to then get hit with an unexpected tax bill for thousands of dollars on that amount.
That would be devastating. So the timing of the cancellation is absolutely critical.
Absolutely critical. And you can see the danger here, right? If the government kept dragging its feet with bureaucratic delays pushing these legally required 2025 cancellations into 2026.
Borrowers would get hit with a huge tax penalty through no fault of their own, just because the processing was slow.
Exactly. That's the nightmare scenario this agreement prevents. It acts like a legal shield. By mandating cancellation on or before December 31st, 2025, it guarantees protection.
How does it guarantee it?
The agreement states clearly that for forgiveness happening by that date, borrowers will not receive those IRS forms, typically a 1099-C, that treat the forgiven amount as taxable income. It legally locks the administration into acting fast enough to ensure that tax protection applies.
Okay, so that makes sense why Winston Berkman-Breen from Protect Borrowers called it a tremendous win. He said borrowers won't be unjustly hit with a tax bill. It really shields them from the consequences of government delays.
It really does. It removes that major source of anxiety for people who are finally nearing the finish line on their loans.
So given all this, the initial resistance, the lawsuit, how do we know the administration will actually stick to this timeline now? What's the enforcement mechanism?
Accountability is built directly into the court-supervised agreement. It's not just a promise, it's an order.
How?
The administration is required to file 6 monthly progress reports directly with the court. These aren't just fluff pieces. They have to detail the actual pace of application processing.
So, hard numbers.
Hard numbers. Specifically, the number of loan discharges being completed each month. It creates transparency and puts the process under direct judicial oversight.
So the court is watching closely.
Very closely. The agreement ensures the government follows through on what the AFT called congressionally mandated affordable payments and debt relief. It's not just policy anymore. It's a court-supervised obligation. And the AFT made it clear they said they will hold the federal government to its word.
That's a strong statement. Okay, this has been incredibly clarifying. So just to recap the big takeaways for you listening.
Yeah, the main point.
First, it took serious legal pressure, specifically that AFT lawsuit from March 2025, to force the administration to actually process forgiveness under these 4 key programs: IDR, ICR, Pay As You Earn, and PSLF. Relief that was already owed.
Right. And second, and this is maybe the most immediate relief for many, the agreement creates that vital tax shield. Getting your loan canceled by December 31st, 2025 means you avoid that potentially massive tax bomb.
A huge weight off people's shoulders.
Absolutely.
Yeah.
But, thinking bigger picture, there's maybe a final thought here, something for you, the listener, to chew on.
Okay.
This entire fight, this whole court case and settlement, it was primarily about forcing the government to deliver on debt relief that was already promised, already embedded in federal law for years, sometimes decades.
Right. It wasn't about creating something new.
Exactly. So the fact that it required such a significant intervention, a federal lawsuit by a major union, ongoing court supervision, just to make the government follow its own existing rules. Well, what does that tell us?
What does that suggest about the future?
Yeah, what does the sheer difficulty of enforcing existing law tell us about the potential stability, the reliability, the actual execution of any student loan relief policies going forward, whether they're old, new, or modified, regardless of who is in the White House? It raises real questions about predictability, doesn't it?
That is a really sobering thought. The question of whether the system can reliably deliver, even when the rules are clear, definitely something to consider. And practically speaking, if you are a borrower in one of those 4 programs,
check your status now.
Absolutely. Review your situation, especially regarding that December 31st, 2025 cancellation window. Make sure you're positioned to benefit from this agreement. Thanks for diving deep with us today.
Thanks for listening.
We'll see you next time.
Don't forget to like and subscribe for the next episode on While We Were Distracted.